unsullied by us humans, sex is a very good part of human life.
We live our lives in a great deal of hypocrisy, telling our children to do one thing while we do something else.
The quest for control. We all would love it if our lives were a bit more controllable.
Discussions within the Christian community about these questions will be primary for the survival of the Christian community.
Oh, excuse me. I didn't know the jury was here. Oh, well, hi. Let me introduce myself. I'm Sam. I'm the bailiff in this court. Our judge sitting by special appointment this evening is the Honorable Dale Young. Judge Young is the only judge in the United States, I understand, to rule on the question of whether a frozen human embryo is the parent's child or the parent's property. You know, I've lived here in East Dakota all my life. And like they said in that commercial a few years back, we've sure come a long way, baby. You know, I thought I'd seen everything in here, and believe me, we have, but today's case is really a new one for me, and it might be a new one for you. I don't know if you've read anything about this case in the papers, but did you know that there's about 38 different ways that we can make a child these days? And I was reading just the other day that there are at least 150,000 frozen human embryos living in labs all over this country. Well, anyway, you're the jury, and the lawyers who will be coming in, I'm sure, very shortly will tell you what it's all about. You know, both lawyers that are here from out of town actually have been arguing issues like this in cases all over the country. But of course, it'll be up to you to decide between the two women who are in this case, both claiming the right to decide what should happen to an unborn child, or fetus, or whatever they call it. One wants the child to be born, I understand, and one wants the child not to be born, but that's about all I know. Oh yes, one more thing. I really hope the judge tells you this. You can keep notes, and you can write down your questions during the trial. And if you have any questions, please feel free to write them down and fold them up and pass them down to the end of your row. I'll be walking around, or some of our other deputies, and we'll pick them up. After you render your verdict, the judge has asked me to tell you that he would like to speak to you. And you'll have a time to ask questions and get some answers from the witnesses and the experts and the lawyers. One last thing. After you hear from the lawyers, they're going to give you a thing they call this opening statement. You might want to indicate in your notes, after you just hear the opening statements, who do you think ought to win this case? And then at the end of the case, after you've heard all of the evidence, you might want to indicate how you voted in your own verdict. See if there's any difference. Well, thanks for coming. I'll see you after the trial. Ladies and gentlemen of the jury, all rise. The Honorable Dale Young, Superior Court Justice of the State of East Dakota, presiding.
You may be seated, ladies and gentlemen. Ladies and gentlemen, this session of the Superior Court of East Dakota is now in session pursuant to adjournment. Ladies and gentlemen, the case that we have ready for trial today is the case of Smith versus Jones. It has a docket number of 9528. The case will be tried to a jury, and you are to be that jury. At the conclusion of the trial, I will ask you to, by a show of hands, tell me the answers to several questions, so you need to listen very carefully to the witnesses as they give testimony during the course of the trial. The case tonight focuses on the relative rights of prospective parents, a surrogate mother, and an unborn child. Mr. and Mrs. Smith are an infertile couple. They have entered into a surrogacy contract with Ms. Jones to carry their baby to term. The baby, however, is afflicted with significant cardiac problems. Ms. Jones wants to abort the child because of the child's potential debility, and Ms. Smith strongly opposes the abortion. Mr. Smith is ambivalent. Mrs. Smith brings this action against Ms. Jones to prohibit Ms. Jones from aborting the child. The surrogacy contract, in pertinent part, provides that Ms. Jones will have the final say regarding all medical questions concerning her health and the mode of delivery. Mrs. Smith contends that Ms. Jones does not have the right to abort the child because the issue is one that affects the health of the child, and it is one that does not in any way affect Ms. Jones' health. Ms. Jones contends that she's the one who's pregnant and that she's entitled to an abortion under her rights given her by the Supreme Court of the United States of America in Roe versus Wade. Now, that's a very brief overview of the facts of the case. The full and complete facts will be known to you as you hear the witnesses testify from this witness stand and give you testimony tonight. I think it would be well for you to consider also the complete statement of facts that you will find in your conference manual. The pages are not numbered, but it's an article, a statement of the case of the elusive embryo by Dr. C. Christopher Hook. So if you'd like to make reference to that as we go, those are facts that are stipulated by the parties as being the facts in this case in pertinent part. Now, some questions that the jury will have to answer at the conclusion of this trial are these, and I merely suggest them to you. Can an individual waive her rights through a surrogacy contract under Roe versus Wade? What rights, if any, does the child have? What rights, if any, does the surrogate mother have? What rights do the genetic parents in this case have? What rights, if any, does the state of East Dakota have in this case? Now, there will be other issues to be developed, and specifically, you'll need to be thinking about answering these questions. First of all, under the law of East Dakota, there can only be one mother. Who is the mother of this child? Under the applicable law of East Dakota, there can only be one woman who has the decision-making capacity regarding the continuation of the pregnancy at issue. Who has that capacity in this case? Is gestational surrogacy an ethical, valid form of assisted reproduction? Do you believe gestational surrogacy contracts should be legally enforceable? Should this court grant the plaintiffs specific request for an injunction, thereby prohibiting Ms. Jones from having an abortion. There may be, as I've already indicated, many other issues that will come up during the course of the trial that you will think about. If you'll remind me of that at the conclusion, we may discuss and may even vote on some of those additional issues. Now, Mr. Palmer and Mr. Nikas, do you have all of your witnesses here ready to testify? How about you, Mr. Palmer?
We do,
everybody? Yes, Mr. Nikas, okay. Would you have your witnesses please stand? And Mr. Bailiff, will you swear the witnesses?
Do you, the witnesses in this case, swear that the evidence that you will give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
You may be seated, ladies and gentlemen. Mr. Bailiff, would you swear the jury?
Ladies and gentlemen of the jury, would you please rise? If you raise your right hand. Do you, the ladies and gentlemen of the jury, swear that you will uphold the laws and the Constitution of the United States in this state, and East Dakota, so help you God?
You may be seated, ladies and gentlemen. Thank you very much. Now, just very briefly, ladies and gentlemen, before we hear testimony in this case and before we hear the opening arguments in this case, I need to thank you in behalf of the citizens of the state of East Dakota for your willingness to serve as a member of a jury panel in this state. It's a vital function that you perform, and it's one you may be called upon in a similar case to perform in the future, and so this is a good training ground for you. I need also to tell you that in a few moments the lawyers will be making opening statements to you. Opening statements are simply, hopefully, brief statements by counsel for the respective parties that will give you an overview of what they expect the trial will show when they put their witnesses on the witness stand. I need to remind you that what the lawyers say during these opening statement times or at any time during the course of the trial is not testimony, and you should not consider it as such. But having said that, I urge you to listen very carefully to what these lawyers have to say to you, because I think it'll help you understand their cases better when you start hearing testimony. The court recognizes Mr. Palmer for opening statement purposes.
May it please this honorable court. Ladies and gentlemen of the jury, as His Honor has told you, my client, Mrs. Smith, has one child, a male child, born to her as a result of this new procedure that we hear about called IVF. The acronym stands for in vitro fertilization. Vitro, if I'm remembering right from my high school Latin class, is simply Latin for glass. And so what the technicians are doing is substituting a tube of glass for the tube of flesh, the fallopian tube. They are not creating life, but they are using the trick of the glass tube to allow infertile couples to then bring the female component, the egg of the woman, and the male component, the sperm of the man, together, and a new life begins. This gives us a background understanding. You heard His Honor mention a case that you may be familiar with, Roe versus Wade. I'd like you to keep in the back of your minds the year of that case. It was vintage 1973. And IVF that we find ourselves in the throes of, Mrs. Smith indeed is really caught in the crossfire of the reproductive revolution. IVF first was tried successfully with human beings. It was known and used in animal husbandry, but the first human in vitro baby was, as you may recall, Louise Joy Brown, 1979. So see, we have the Supreme Court speaking. We'll come back to that later, but remember, what they said in Roe v. Wade was said in 1973. It was to be another 6 years before we witnessed the world's first in vitro baby. Now, as His Honor has mentioned, and the evidence will show, Mrs. Smith initially conceived 7 preborn children as human embryos, which to her are children in being. 4 were taken first and implanted in the temple of her womb. To her, it is a temple of the womb. By analogy, again, we might think, as we walked into the courtroom this evening, we would call this a building. It is used as a courtroom tonight. But if this same building is reconvened as a chapel, reconvened for worship, we call it a chapel. It is a building to see it. When it's convened for worship, it is a chapel. In anatomy class, we learn that this is the uterus of the woman, in which the human embryo attaches to the endometrium. But to Mrs. Smith, when the preborn child is present in the uterus, it becomes the temple of the womb. Ushering forth from that temple was her first child born. But as a result of the process of labor and delivery, she lost her uterus. She now realized, and her husband, that 4 of her in vitro children in being were in the concentration camp of the liquid nitrogen, in the deep freeze. And she felt a duty within her heart and soul to rescue them from the cold and return them to the warmth of life. She felt a duty to ask some woman if she would be kind enough to bear them to term so that they might live. And Mrs. Jones, fully informed, the evidence will show they had a discussion, and it was understood that Mrs. Smith, the evidence will show, was always to be considered the natural mother, and Mrs. Jones would assist in bringing her child or children to term. And the judge has told you pretty much the rest of the story. We, at 3 months gestation, using a new trick of modern technology called ultrasound, or the more sophisticated derivative of real-time ultrasound, that has put windows on the womb, are able to do what our grandparents would not have dreamed of. We can park the curtains and peek into the window on the womb. And we see her baby waving back at us. Little Mary Thumb turning somersaults, dancing in utero. But the physicians see something else that is ominous. A storm cloud on the horizon. A heart anomaly. And little baby might not live to be born. She might live to be born, the evidence will show, and she could indeed have the anomaly corrected before she leaves the hospital. Or it could not be corrected by the time she leaves the hospital, and it could be great difficulties for many years to come. But Mrs. Smith, the evidence will show, she and her husband are supportive of the preborn child, that they will do whatever it takes. They will spend whatever it takes. They will make it an investiture of their time and their love and their being to give the gift of love so that their child might live. Now, under the law of East Dakota, as His Honor has instructed you, there can be, the law is telling us, only one mother. It's important to keep in mind in the course of the case this evening that there is something different here from what we first learned about on the front pages of the Life magazines and the People magazine. This is not a straight surrogacy arrangement in which both Mr. and Mrs. Smith are infertile and can't have children. Let's say Mrs. Smith cannot give an egg, but her husband is fertile. This is not a straight surrogacy arrangement where Mr. Smith's sperm was implanted in Mrs. Jones. That's a straight surrogacy arrangement. But rather here we have two women, both contributing a female part to bringing about the preborn child. Mrs. Smith is donating the ovum, the egg, which, by the way, here you'll learn was fertilized anonymously because of her husband's infertility. But, so she is the genetic parent. Mrs. Jones is offering to be the gestational surrogate. But you understand, of course, when the baby is born, it will have none of the characteristics of Mrs. Jones, none of her genetic signatures, but all of the characteristics of Mrs. Smith and the anonymous donor. We would respectfully proffer, ladies and gentlemen, that at the close of the evidence this evening, that you will find that the true mother is Mrs. Smith. Thank you.
Thank you, Mr. Palmer. Mr. Nikas, you may address the jury very briefly, please.
Thank you, Your Honor. May it please the court. Ladies and gentlemen of the jury, this is a case about liberty, about freedom, about what many Americans believe to be the most fundamental and cherished right of the last generation, the right of a woman to choose to terminate her pregnancy. My name is Nicholas Nikas, and I represent the defendant in this case, Mrs. Lydia Jones. Mrs. Jones is married and the mother of 2 sons. Now, as the court has stated, the opening statement is the time for the attorneys to give a brief summary of the testimony you're about to hear. Legal argument is really appropriate for the close, and that's where I'll leave it. Here's what the evidence will show. Mrs. Smith, as a result of her own conduct, undertaken previously, cannot get pregnant. Consequently, Mrs. Smith needs to use another person to achieve the goals that she wants. Specifically, she needs to use another person's uterus, and in this case, she's using, at this moment, my client's uterus. Mrs. Jones, so out of the goodness of her heart, no fee, agreed to serve as the carrier for this pregnancy that Mrs. Smith could not achieve. The testimony will make clear that Mrs. Jones wanted to do something great for the world, to bring to term a healthy fetus. But tragically, the evidence will also demonstrate that the fetus might come to full term with potentially devastating heart defects. As a result of this knowledge, what began for my client, Mrs. Jones, as a heroic and altruistic act of self-giving, has become a living nightmare of ever-increasing emotional distress, suffering, and deep, profound personal sadness. Consequently, to preserve her mental health, she seeks to terminate the suffering by exercising her constitutional and contractual rights. Now, this is only a brief summary, but I know that once you fairly and impartially reserve judgment and carefully considered the testimony you're about to hear and the law as it exists today, you will, in assisting Judge Young, rule that the injunction that plaintiff seeks should be denied, thereby letting my client make the most intimate and self-defining of personal decisions. Thank you, ladies and gentlemen, for your patience, and I look forward to talking to you at the close of this case.
Thank you, Mr. Nikas. Mr. Palmer, the plaintiff may call her first witness.
We call to stand, Your Honor, Mrs. Smith.
Come around, Mrs. Smith, and remember that you remain under oath to tell the truth.
State your name and address for the record, Ms. Smith.
I'm Mrs. Joyce Smith. I live at 123 Grant Avenue in Cherokee, East Dakota.
Okay, now, Ms. Smith, why can't you bear your own children?
Well, my husband and I have had infertility problems, and we've always wanted to have children. So when we heard this sad news, we decided to undergo the IVF procedure. And in that procedure, they took the eggs from my ovaries, and then they took those out, and then they mixed them together with some sperm from a donor. We couldn't use my husband's sperm because his sperm isn't able to fertilize my eggs. But then once those were fertilized, they took those embryos and placed some of them into my uterus, and I became pregnant, and as a result of that, my son was born.
What's his name?
His name is Mark.
Now, why did you choose to ask Mrs. Jones to bear your child rather than donate the embryos anonymously so that the couple would then adopt these children?
Well, they're my children, and I couldn't have done that because I have the responsibility for those children. And I couldn't bear them myself because when I was pregnant with my son, unfortunately, I lost my uterus. It was taken out, and so I had to find somebody to do that for me.
Now, Ms. Smith, were the child to be born, would you claim to be the child's natural mother?
Yes, of course.
And would it be fair to say that you and your husband, will you raise the child regardless of her physical state?
Absolutely. We don't care about the fact that she may have heart defects. We care about her as a child.
By the way, Mrs. Smith, we do in fact know the sex of the preborn child and being, do we not?
Yes, we do. She's a little girl, and
Have you given her a name?
yes, we're going to call her Beth, and my son's very, very excited about having a little sister.
How old is your son again?
My son is only about 4.
But he understands he's going to have a baby sister, and
Yes, he does, and he is so excited.
Mrs. Smith, have you and Mrs. Jones ever discussed who is the child's natural mother?
We had many conversations about that, and there wasn't any question in her mind at that time or in mine. I'm the natural mother. Clearly, I'm the natural mother of this child.
So she understood that. She didn't disagree with that.
No, of course not.
Now, Ms. Smith, the physicians have stated that your baby has serious problems, difficulty with the heart. Yet you've asked Mrs. Jones to continue to bear this child.
Yes.
Tell the ladies and gentlemen of the jury in his honor why.
Well, I just don't think that the doctors are able, at least at this point. In fact, the doctors have even told us that they can't predict what the severity of these defects are going to be. Certainly, I don't think Mrs. Jones can if they can't. And so but it doesn't even matter to me. I want to have my baby. I want my baby to have a chance to have life. I just can't understand how anybody could have, out of some kind of misguided sense of compassion, want to kill a little innocent girl, a little innocent baby. I know Mrs. Jones is worried about my baby suffering, and so am I. I don't want my baby to suffer, but I just don't think that suffering should be a reason to kill somebody. I think that God can bring good out of suffering. And I also think that God sees my child as having worth, and so do I. And I want her to have life. I think what she's doing is just wrong. It's just not right.
One final question, Ms. Smith. In your agreement with Mrs. Jones, You gave her final decision-making authority, did you not, over matters concerning her health?
Yes, I did.
Okay, for the benefit then of the ladies and gentlemen of the jury and His Honor, why do you maintain that her decision to now abort the child is not within the discretionary authority that you gave her?
Well, when we talked about it, we certainly agreed that in matters of her own personal health, if her personal health was going to be affected, that she should have some say about what to do. But this baby's defects are not affecting her personal health beyond just the normal discomfort that you have when you're pregnant, and she agreed to do that. And so I don't feel like it's her health that's being affected at all here. It's only my child's health that's an issue here.
So then what you're saying, Ms. Smith, is that cardiac problems are not contagious to the mother bearing the preborn child.
That's right.
Your witness, counsel.
Now, Mrs. Smith, you lost your uterus after using the IVF procedure, correct?
That's correct.
And because of this loss, you must use someone else's uterus to achieve what you want. Isn't that right?
Yes.
And you are, in fact, as we speak, using my client's uterus, aren't you?
Well, yes, I don't...
Yes? Thank you. Now, you really treat her as nothing but a biological container. Isn't that right?
No, that's not true at all. I see her as the guardian of my child until my child is born.
Do you see her as a person?
Yes, of course I do.
Now, Mrs. Smith, if you had your own uterus and you could carry your own child, you would do so, wouldn't you?
Yes.
And if you were pregnant with your own child and someone came up to you and said, do the world a favor and abort that child, you wouldn't do it, would you?
No, because I'm the mother.
You wouldn't do it because it's your decision to make, isn't it?
Yes.
Now, when you agreed to undergo the IVF procedure, you were informed that some or even all of the embryos might spontaneously abort, didn't you?
Well, yes, my doctors told me that that was a possibility, but we also knew that some of them, that all of them could be implanted.
Mrs. Smith, my question is very simple. You were informed that some or even all of those embryos could spontaneously abort. Weren't you informed?
We knew that was a risk.
Okay. And you were willing to sacrifice those children to get what you want?
Well, we wanted to have a baby.
No, Mrs. Smith. It's a yes or no question. You were willing to sacrifice those children to get what you wanted, yes or no?
Yes.
So you really don't have a problem with abortion, do you?
Oh, wait a minute. This is not abortion that we're talking about here. What's abortion is what this woman wants to do to my child. She wants to abort my baby. We didn't want to kill those embryos. We wouldn't have transplanted them if we would have. We felt that the lives of those embryos were in God's hands. And what she's doing is playing God. She wants to kill my baby. That's a different situation.
Playing God, that's very interesting, Mrs. Smith. Didn't you play God when you allowed some of your children, as you call them, to be frozen?
Well, well, no, of course not. That's not what we had in mind at all. We didn't want those babies to die. We wanted to have another child.
Speaking of frozen, you knew that when they thawed, that a significant percentage of those children would run the risk of dying, didn't you?
Well, yes.
And you were willing to run that risk to get what you wanted, weren't you?
Well, no, that wasn't our idea at all. I had no options. I had to do something. We needed to save these children.
Save these children from a condition that you created. No further questions, Your Honor.
All right. Any redirect, Mr. Palmer?
None, Your Honor.
All right. Come down. Call your next witness.
Your Honor, we'd call to the stand Dr. Christopher Hook.
Come around, Dr. Hook, and you have been sworn, haven't you? All right. Please have a seat in the witness box.
Doctor, state your name and address, professional address for the record, please.
Dr. C. Christopher Hook. I work at the University Hospital of East Dakota.
All right. And if you would, Doctor, direct your comments to the ladies and gentlemen
Yes,
of the
sir.
jury. They have
Yes,
to
sir.
make the decision here that's so important this evening. What is your profession, Doctor?
I am an internist and a medical ethicist, sir,
And where do you perform your professional duties?
at the University Hospital of East Dakota.
Now, you would agree, would you not, Doctor, that for an agreement between two people to be valid, it's important that the agreed-upon activity is morally acceptable?
Absolutely, sir.
Now, Doctor, you've written extensively in the literature on the matter of ethics in just this sort of a situation. Can you give us your wisdom, your understanding for the case that this court is presented with?
Well, the first question that we are addressed with is the idea of surrogacy in bearing a child. A surrogate is someone who stands in for someone else, a pinch hitter, as it were. It's important to understand that there are two types of surrogacy that we could be considering. One has been alluded to earlier, that of the traditional surrogate, in which a woman is artificially inseminated but maintains a genetic relationship with the child she then bears and is asked to give up. This is a situation, because it is indeed her child, genetically, that I categorically condemn, or uncategorically condemn. We're dealing here now with a case of a gestational surrogate, in which...
The word gestation, Doctor, to help me, and perhaps the ladies and gentlemen, what does that mean?
It means someone who is essentially helping the child develop to the point where they can exist after birth.
Okay.
A guardianship for that time of development. There is no genetic relationship between the woman who is carrying the child and the child itself. And therefore, it would be more reasonable under significant circumstances to allow her to do that for another individual as an act of altruism and then give up that child at the end of the pregnancy.
Doctor, now let me ask you, if I may, ordinarily would you propose to freeze, cryopreserve, in the very cool liquid nitrogen, very small children, human embryos?
No, sir, I would not, because of the risk that they may not survive that process and the thawing thereafter.
Let me ask you further, Doctor, that presented with the facts of this case, where when we brought you in for your expertise and your learning and your wisdom, we already had a baby in the fridge.
Absolutely.
What do we do now?
Well, that changes the situation.
What is morally proper to do now?
In a situation like this, in which we have the embryos already cryopreserved, it becomes obligatory that we do what is possible to enable that child to fully develop and be born. And that is what Mrs. Smith has done when she went to Mrs. Jones to ask her to help her in this situation, because Mrs. Smith could no longer bear those children herself.
Okay, now that's, again, Doctor, because I always need to think of something in some common sense words that I can hang on to. Let me give you this analogy and tell me if this fits.
Okay, sir.
Are you saying that while ordinarily it would not be advisable to place your child out on the ledge of the Empire State Building in the cold, up very high, that you would not advise this morally, that once this has occurred, you're saying it is okay to have a surrogate go out and rescue this child and bring this child back into safety and warmth? Is that...
Well, it's not only just okay, but it's obligatory. It is a moral obligation for all to do what is necessary to rescue that child.
But that's something like what you're saying.
In essence, sir.
Okay. All right. I need common sense shirt sleeve English to remember it tomorrow morning.
All right, sir.
What criteria or criterion would you delineate for this situation, Doctor?
Well, once we have the situation where we do need to perform this act of rescue, we do need to recognize that the person who is asked to participate in that does have certain rights. In other words, that this be a voluntary act, that it be performed without coercion, without remuneration. It must be an act of altruism. And so it must be fully voluntary. And we also would then require that the individual participant be fully informed of what it is that they are participating in. Therefore, it's always best that the individual have borne a child herself so that she understands the full implications of being pregnant and going through childbirth, and also that she understands that she is not expected to have any ongoing responsibility for that child once it is born, and that it is her responsibility to give that child over at the time of delivery.
Dr. Hook, let me ask you this. Have you had an opportunity to review the facts of this case?
Yes, sir, I have.
Does the agreement between my client, Mrs. Smith, and Mrs. Jones fulfill those criteria that you've just enunciated for acceptability?
Yes, sir, it does.
Doctor, this case is confusing because it appears that we have two women claiming to be making the best decisions for the child. In your opinion, doctor, who is the mother of this child?
Mrs. Smith is clearly the mother of this child.
Why?
She is the genetic mother. She is the intended social mother. She will raise this child. She assumes all of those responsibilities. And importantly, she desires this child. She is looking out the best interest for this child. And between the two women, she is the one who wants this child to live.
I see, doctor. Doctor, according to the Supreme Court decision of Roe v. Wade, I'm sure you're familiar with that.
Yes, sir.
It stated that women have the right to abortion. Isn't Mrs. Jones simply exercising that right?
No, sir.
Why do you say that?
I contend that Roe does not pertain in this situation. The facts of this case are very, very divergent from the facts of Roe.
When was Roe decided, doctor?
1973.
Can you tell us, I think you told me previously is why I knew it, the fact to mention it in my opening, but when was the first IVF in the world?
The first child born by IVF was in 1979.
So then it was approximately 6 years after the fact.
Yes, sir.
That this new science entered the stage of reproductive possibilities in the world.
Yes, sir.
I understand that Blackman did some of his work on the Roe v. Wade opinion in the bookshelves there at Mayo. Is that correct?
Yes, sir, he did.
Would he have had any intimations or any knowledge that something that we came to call IVF would be around the corner?
That was not part of the thinking of the case, as I understand it, sir.
Finally, doctor, let me ask you this. Given the facts of this case and the question before this honorable court and these ladies and gentlemen of the jury, do you have a recommendation for the court that will be eliciting recommendations in turn from the jury so that this jurors can decide?
Yes, sir, I do.
What is that recommendation?
I recommend that the court move to preserve the life of this child and to prevent Mrs. Jones from destroying this life.
We thank you, doctor, for coming all this way and for sharing your wisdom with us this afternoon. At this point, I'd invite opposing counsel to take you as a witness.
Now, Dr. Hook, you're testifying tonight in your capacity as a medical ethicist, correct?
Yes, sir.
And you're not testifying tonight as a legal expert, are you?
No, sir.
So any opinion you give on the application of Roe v. Wade to this case is given solely in your capacity as a medical ethicist, correct?
That is correct, sir.
Now, you know, doctor, maybe I didn't understand something, so you can help me out. And I'm confused because I thought in your testimony you first said that generally speaking, you don't favor gestational surrogacy contracts. Is that correct?
In general, I would say that is true, sir.
Doctor, it's a yes or no answer. Do you generally favor gestational surrogacy contracts? Yes or no?
No, sir, I do not.
In fact, it's actually even stronger than whether you favor it or not. Generally speaking, you believe those contracts to be immoral, correct?
Other than in the case of rescue, yes.
Now, in layman's terms, doctor, and you're an ethicist, if something is immoral, it shouldn't be done, correct?
Correct.
But conveniently, I guess, doctor, you believe that rescue surrogacy contracts are morally acceptable, correct?
Absolutely.
Well, then tell me something, doctor. If the mother herself places the child on the ledge of the building, is that a moral act?
I would not advise it, sir.
Is the answer no, doctor?
No.
No further questions, Your Honor.
Any redirect, Mr. Palmer?
We have none.
Okay, you may come down.
Your Honor, that's the plaintiff's case.
All right, the plaintiff rests. All right, Mr. Nikas, you may call your first witness.
Thank you, Your Honor. Defendants call Mrs. Lydia Jones to the stand. Mrs. Jones, would you please state your full name to the jury?
Mrs. Lydia Jones.
And what is your occupation, Mrs. Jones?
I'm a wife and a mother.
Mrs. Jones, please tell the jury if you have ever been pregnant before.
Yes, I have 2 sons.
Tell the jury what it was like for you to undergo those 2 pregnancies.
I think as most people who've been pregnant would tell you, it's very hard. It's hard physically. Your body changes in so many ways, your back, your feet. It's hard emotionally. You're going through so many changes inside. And delivery and labor can be very difficult. They were in both the cases with my sons.
Now, Mrs. Jones, were the fetuses you carried to term healthy during the pregnancy?
Yes, all the way.
Mrs. Jones, please tell the jury, why did you agree to be the gestational surrogate for the plaintiff in this case?
I have been involved in causes that I believe in all my life. And since I've had my 2 little boys, I've chosen to stay home with them and haven't been able to really give back much in several years. And so my husband and I discussed it, and we decided that this would be a great way that I could give something back to our community, to the world. That's what we thought at the beginning.
And tell the jury, has anything changed since you first agreed to act as a surrogate?
Yes, everything has changed.
Tell the jury what's changed, please.
When I went in for the appointment at the end of my first trimester of pregnancy, the results came back that the baby has some significant cardiac problems. He might not survive, and even if it does, it's going to probably have severe problems its whole life.
How has this knowledge affected your family, your family?
It's changed everything. Since I got the knowledge, I haven't really been eating or sleeping right. It's all I think about. I feel like I'm obsessed with this, that instead of doing something really good for people or for this family or for society, I am bringing in somebody that's going to be creating great problems for her and for her son and for the community. I don't have the energy now to be a good mother to my own sons. My husband and I are having problems. It has changed my life completely.
Mrs. Jones, tell the jury, do you want to continue this pregnancy?
No, I do not.
And if you are forced by the weight of government power to bear the unbearable, how will that affect you?
Objection, Your Honor. There's no indication of government power here. This is a court of law. Your Honor's going to make the decision. The jury's going to. What government power is he talking?
Your Honor, may I respond to that?
Yes, you may.
The court, of course, Your Honor, is an arm of the state. And if the court issues an injunction forcing my client to bear this child, that's a clear exercise of government power.
You may have the last word, Mr. Palmer. It's your objection.
Well, Your Honor, he's inferring that while In fact, it's truly stated that the court is an arm of the state. This court does not twist arms, but this court judicially weighs and considers the evidence. This is a weighty decision we're to make, and it's not to be made to appear that somebody's going to force something without the province of the jury and without due judicial deliberation.
Gentlemen, I'm of the opinion that it's a fair question for this jury to be presented with and to answer, and I therefore respectfully overrule the objection. All right, Mr. Nikas.
Mrs. Jones, let me ask that question again. If you are forced by the weight of government power to bear the unbearable, how will that affect you?
I honestly don't want to think about how it would affect me already. I can see effects in my own boys. I can see my husband doesn't want me to have this. I would be being forced to do something that I think is wrong. I'm not me anymore. I'm not who I know who I am. I'm not a good wife. I'm not a good mother. I'm not even a good person. I don't want to think what would happen if I have to continue.
Mrs. Jones, if you are not forced to continue this pregnancy, what would you do?
I would stop it.
Thank you, Mrs. Jones. No further questions, Your Honor.
All right. You may cross-examine, Mr. Palmer.
Ms. Jones, it's apparent that this is an emotional moment for you, isn't it?
Yes, sir.
Let me ask you, if all had gone well, if there had been no heart anomalies show up on the sonogram, would you be happy right now?
I'm sure I would be happier than I am right now.
So then what you're feeling is because of the heart defect, you feel that if this were your own child, you would not choose to bring the child to term, but you would in fact have an abortion. Is that what you're telling us?
That's correct.
And you feel that would be best for all concerned? For you, for your husband, for your children?
Absolutely.
For Mrs. Smith?
Yes.
You take it into your province to decide that for her. And for the child?
Yes.
And you decide that for the child?
Yes.
You feel feelings, don't you? You get caught up in the truth of your emotions, do you not?
I guess so.
Let me ask you this. Have you heard of something called post-abortion syndrome?
Yes, I have.
Have you considered that even if you go forward with your decision, or allowed to abort the preborn child within you, not your own, taking it out of the hands of Mrs. Smith, that later you could experience the impact of that is a possibility down the line for you?
I can't imagine feeling any worse than I'm feeling right now.
Mrs. Jones, with a child to be born, would you claim to be the mother?
No.
Would you put your name as mother on the birth certificate?
No.
Would your husband's name appear as father?
No.
Have you prepared to bring this child into your home? You're going to bring it home from the hospital when it's born? Were you planning on that?
No.
It goes with Mrs. Smith, is that correct?
Yes.
Have you or your husband told your friends that you're going to have a baby, or Mrs. Smith's baby?
Mrs. Smith's.
When blood tests of this baby are taken, whose genetic markers will be found, yours or Mrs. Smith's?
Mrs. Smith's.
So Mrs. Smith is the genetic mother, right?
Yes.
And the Smiths are the intended parents of this baby, not you and your husband, correct?
Correct.
And it's the Smiths, under the terms of your agreement, that are to provide a home for this baby, not you and your husband, is that correct?
After the birth, yes.
No one has told you that giving birth to this baby will kill you, have they?
No.
No one has told you that giving birth to this baby will damage your physical health beyond having a baby at any other time as having your other two children. Is that correct?
No one's told me that, no.
But if this child was born without birth defects, you would be proud of yourself and happy for the Smiths, right?
I suppose.
And even if the child were born with birth defects, you will be happy for the Smiths if those birth defects could be permanently cured and corrected surgically before the child leaves the hospital, would you not?
If that were the case, I would be happy, yes.
Do you think that disabled Americans ought to have the same rights in life as able Americans, so long as they're not a danger to themselves or others?
Objection, Your Honor. Relevance.
We withdraw the question, Your Honor. Would you be carrying the baby you're carrying now without the agreement you and your husband entered into with the Smiths?
No, I would not.
Okay. Now, Ms. Jones, you entered that agreement freely and voluntarily, did you not?
Yes, I did.
You promised to carry the baby to term in that agreement, didn't you?
With certain stipulations, yes.
But you gave up your right to claim it as your own child in that agreement, is that correct?
Yes.
Including the right to make health care decisions for the baby, correct?
Yes.
But you didn't give up the right to make health care decisions for your own health.
No, I did not.
Okay. Assuming that the pregnancy is a condition, not an illness, you've not been diagnosed with any physical illness at this time, have you?
I've not been diagnosed, no.
You're just worried about the health of the baby that you're carrying within the temple of your womb, is that correct?
And the health of myself and my family.
And it's that worry that you believe is and will continue to impact your health, is that correct?
Absolutely.
Now, Mrs. Smith wants the baby to live. You understand that, of course, correct?
Yes, I do.
Mrs. Smith, let me give you a little example that maybe helps me understand it. To put it in a simple understanding, what if I were to say that this is your child, your little girl, within the temple of your womb, and you find out that it would have these heart difficulties, these troubles? Would you go home and say to your two children, your little boys, that, guys, we're not going to have your little sister after all. She'll bring too much pain among the family. She's too much for us. We can't learn to love her. It'll be too difficult for you. She's not perfect enough for us. Children will give her back to God and say we're not happy about what He's given us. Please take her back. Would you do this? Would you be able to do this? Explain this to your children like this.
I can't answer about something that hasn't happened.
What if your little boy, Miss Jones, looks at you and says, Mommy, I'll love her. What would you tell him?
These aren't the facts of the case. I have no idea what I would say.
Mrs. Jones, what do you really want for this baby?
I want what is best for the baby and for everybody involved, and that's what I'm trying to do.
We understand. Thank you, Ms. Jones.
No,
Any
redirect.
redirect? All right, you may come down. Thank you. Defendant may call your next witness.
Thank you, Your Honor. Defendants call Dr. Mitchell to the stand. Dr. Mitchell, would you state your full name for the jury, please?
C. Benjamin Mitchell.
And Dr. Mitchell, what is your occupation?
I am a family practice physician and also run an ethics consultation service at the West Dakota University Medical Center.
Now, Dr. Mitchell, were you in the courtroom when Dr. Hook testified previously?
Yes, I was.
And did you hear Dr. Hook's testimony that, in general, he believes surrogacy contracts are immoral?
Yes.
Do you agree with that statement, Doctor?
No, I don't.
Let me ask that question again, Doctor. Dr. Hook's testimony was that in general he believes surrogacy contracts to be immoral. Do you agree with that?
Well, I would go further, and I would say that all surrogacy contracts are immoral.
So when Dr. Hook testified that what he calls rescue surrogacy contracts are acceptable, you wouldn't agree with that?
No, I wouldn't.
Okay. Why not?
Well, there are several reasons that I think these kinds of reproductive arrangements are problematic. First of all, I can't imagine an exception in which a surrogacy contract would be acceptable, a surrogacy arrangement would be acceptable. Secondly, in order to have a rescue arrangement, typically you would have to have a person who's being rescued. My understanding of the law, my understanding of the morality of the situation is that the fetus is not a person. In fact, the fetus doesn't meet the criterion for personhood, and therefore we don't have a rescue analogy at work here. And then thirdly, these types of reproductive arrangements tend to objectify women. They make women merely uteruses with legs, biological containers, merely the receptacle for another person's reproductive desires. And I think, therefore, these kinds of arrangements can never be morally acceptable.
Dr. Mitchell, are you the only person in your field who holds this view?
No, there are not only a number of other ethicists who would hold this same position, but states, many states in the United States have imposed restrictions on these kinds of reproductive arrangements, as well as a number of European countries.
Now, Dr. Mitchell, have you reviewed the contract that's at issue in this case?
I have.
And in your review, have you seen in the contract a provision that grants full and sole authority to my client, Mrs. Jones, to make all decisions relating to her health and the pregnancy?
Yes.
Now, doctor, assume for me, for the moment, if you would, that gestational surrogacy contracts are enforceable in this state. Make that assumption. And I understand your view that they're immoral, but assume they're enforceable. Would the provision in the contract allowing my client the right to make the decisions regarding her health and the pregnancy, would they be morally acceptable?
Under the terms you've stipulated, yes.
So if Mrs. Jones is experiencing severe and profound emotional distress and exercises her rights under that contract, would that be a moral act?
Absolutely, and to do otherwise would make her a slave for the next 9 months or 6 months.
Based on your study and the analysis of this case, do you have a recommendation for the court and for the jury in this case?
Yes, I recommend that the court deny the injunction and that your client be permitted to terminate the pregnancy.
Thank you, Dr. Mitchell. No further questions, Your Honor.
Thank you, sir. May cross-examine.
Doctor, I believe you stated that in your view, the preborn child in being here, I believe you used the term fetus.
Yes.
You indicated that Mrs. Smith's 3-month-old preborn child, 12 weeks, is not a person. Is that what you said?
Does not meet the personhood criteria. You're right. That's correct.
When her preborn child was first conceived in the test tube, was her preborn child a person then, in your view?
No.
What was she?
She was a pre-embryo or zygote, or there are a number of terms that could be used to describe that stage of gestation.
Essentially property that we can do with.
Yes.
Let me ask you this, Dr. Mitchell. If the test tube were to say, "This is my property," would anyone believe the test tube?
I'm sorry, I'm not sure I understand your question.
Well, you've indicated that at this stage it's mere property. So I'm simply asking that if the test tube were to say, "This is my property," as the woman says, would anybody believe the test tube?
Well, it'd be a very peculiar test tube that could say anything.
You've stated that you're an ethicist, correct?
Correct.
Are you familiar with the Ten Commandments?
Generally.
Would you give us the sixth commandment, Doctor?
You shall not murder, you shall not kill. Now, I take that to mean that you should not take another person's life unjustly.
Well, then let me ask you, Doctor, what has Beth Smith, the child of Mrs. Smith, done here to deserve the justice of a death sentence?
Well, of course, I dispute that we have a child here. We have a fetus, but we don't have a child. And so this fetus is posing a health risk to Ms. Jones, and therefore the analogy, the notion that we have a child here is not apropos.
Doctor, I'm 54 years old, exactly. If I add 9 months to that and tell you that I'm a 54-year, 9-month-old fetus, what do you make of that statement?
Well, you'd be indeed a peculiar fetus as well.
Was I any less an equal member of the community of man when I was 3 months gestation?
Would you state that one more time, please?
Was I any less, backing my fetology up now, 54 years and 6 months, was I any less, in your ethical opinion, was I any less a member of the community of man at 3 months gestation in the temple of my mother's womb?
In my opinion, yes. You were less at 3 months than you are at 54, 55.
But less a member of the community of man.
Yes.
And would you agree that a fundamental principle or rule is the statement that we should do unto others, Doctor, as we would have them do unto us?
I think that's an acceptable moral principle, yes.
No further questions.
No redirect, Your Honor.
Thank you. You may come down, Doctor. Do you have further witnesses?
No, Your Honor.
Okay, the
Defense rest.
The defendant rests. Are there rebuttal witnesses for the plaintiff?
We have no rebuttal, Your Honor.
All right. Thank you very much. Now, ladies and gentlemen, I feel like I need to remind you one more time that what the lawyers say is not testimony, so don't consider it as such. But these lawyers are going to give you closing arguments. They're going to sum up their parties' cases for you in a capsule form, hopefully to help you better understand what you have heard now from their point of view. So for those purposes, the court recognizes Mr. Palmer for a closing statement.
May it please this honorable court. Ladies and gentlemen, you've heard the facts, you've heard the evidence. And both the facts and the evidence wash across your hearts. And I use that heart as an important word, because the great truth of all law is that ultimate law is written upon the heart and mind of man by the Creator. Not to make our profession any less, but there's no special learning of the lawyer. The law is nothing but common sense made difficult, or is modified from time to time by the legislature. This is a reason for juries. This is a reason for bringing you together so that your wisdom can be imparted to the heart of this noble and learned jurist, and so that he can make a just and a wise ruling here this evening, not just for my client, Mrs. Smith, and not just for her preborn child and being, but for all of the little ones yet to come. You know in your hearts and minds as much law as any Supreme Court judge. I promise. Because when we think of the truth that the law is written upon the heart and mind of man by the Creator, then what we as human beings do with laws becomes like a paper tracing. When it lines up, we say it is just and true, like the Declaration of Independence. When it does not line up, we say that law is indigestible to our republic, as is Roe v. Wade, the case that my opposing counsel, I expect, will rely upon this evening, in seeking to compel what he would call a termination of the life of the fetus, to vacuum out undifferentiated cells, to terminate a pregnancy. But what my client, Mrs. Smith, views as the only way you can terminate a pregnancy, which is merely a hormonal condition, is to eject the preborn child and being from the temple of the womb. Oh yes, you've terminated the pregnancy. Just like when they all leave the chapel and you lock the doors, you've emptied the building. But the building is sound. The filtered stained glass windows that curiously are an imitation of the filtered red light of the womb within that chapel now filter their light upon an empty chair. It's life, it's worship, it's consecration. Is missing. With that in mind, let's think out this case together. Mrs. Smith is truly caught in a crossfire here of this reproductive revolution. Man, when he's given technology, must pray for the wisdom to handle that technology. For the reality, I'd respectfully submit, is that the preborn child, the human embryo, immediately following fertilization, glows with a white-hot incandescence, if we could see it, having just been released from the fingertip of God. I'd like you to repaint in your minds Michelangelo's Sistine Chapel. If he were painting that today, perhaps he'd send a message. Echoing down through the corridors of time, by substituting for the fingertip of Adam reaching back, the human conceptus that would fit on the tip of a pin and yet contains more information perfectly organized than would fit in 1 million NASA computers. Everything necessary for the preborn child to build herself. Even the brain, capable of going to the moon and putting foot on the moon, is there in the very beginning. There is nothing added. It is all locked in. She builds and extends, as she did within the temple of Mrs. Jones' womb, her own scaphandre, her own spacesuit. She extends her own umbilical cord to, like the little astronaut in utero, to hook onto the mother's ship for oxygen and nutrients. We owe it to the little astronaut to not disconnect her from the mother's ship. But we say defect. In this throwaway society, we take it back, we exchange it, we want our money back, we give it back to God. It's defective. One word, Joni Erex Tyler. Would we have given her back? She almost, she said, gave herself back. And because of an accident in life, she became defective. Let's assume that Joni Ereckson Tada, we could see on the sonogram, would be wheelchair bound upon birth. If we reject her, who made the blind, the lame, the dumb? God says, I made them. We reject his wisdom. And my, would we have passed something up. Everything the little preborn child is to be is written there in the very beginning. Even how long she will live, accident or sickness not intervening, is there from the beginning. To tell the rest of the tale of little Mary Thumb, we have to allow her to stay within the filtered red light of the temple of the womb, consecrated by her. A woman who enters into a gestational surrogacy agreement is not exercising, this is the legalese lawyer talk now, we see that Supreme Court judges first decide what they want to do, and then they pretend they found the law to do it. So we're doing that, aren't we? We're deciding what ought to be done now. We'll find some law that we can say, the law made me do it. Right? Really, they do it. The heart does it. The heart is true law. A woman who enters into a gestational surrogacy agreement is not exercising her own right to make procreative choices. She's agreeing to provide a necessary and profoundly important service without, by definition, any expectation that she will raise the child as her own. Mrs. Smith is not a genetic donor. She never intended to be. Because she never intended to donate her genetic material to anyone. She never relinquished her rights in her preborn child. To determine who is the legal mother of a child born of a gestational surrogacy agreement, we must apply the standard most protective of the child's welfare, the best interest of the child test. Some phrase of the lawyers and judges. It's common sense, isn't it? What's best for the child? Who wants the child to live? This case, as Dr. Hook has eloquently explained, he's given us the science. It's different from a straight surrogacy agreement where the woman is impregnated with male sperm. The gestational surrogacy has two aspects of the female role in the reproduction, and they're divided between these two women. The mental concept of the child, I'd respectfully submit, is a controlling factor of her conception, and the originators of that concept merit full credit as conceivers. You know, when we think about it, it's curious. We use the same word, don't we, to speak of conceiving an idea or conceiving a child. And when a couple conceives of having a child in love that they will love, this is the beginning of what next becomes the true conception. But first they conceive the idea. And that idea belongs to them. It cannot be taken away from them. And the preborn child belongs to herself. And Mrs. Smith views herself as merely a guardian for God. The idea of the child and the conception of the child should take place in love, and it's that bond of love to the child that causes Mrs. Smith to be willing to see her child through the great difficulties that she knows could lie ahead. We'd respectfully submit that while a heart defect is not contagious to Mrs. Jones, denigration of the equal humanity and personhood of the preborn child is contagious. And if you allow this, ladies and gentlemen, it sets a precedent that others can do the same. Reject, cut off, send back the defects. We remember in the Middle Ages that they treated mental illness by smothering the patient between two mattresses. I respectfully proffer that we are poor scientists and not so good doctors if we attack the patient instead of attacking the disease of the patient, or in this case, the defect of the heart. I'll give you one example that I can remember, dealing with another defect, and now the world sorts out genetically a priori ahead of time, Down syndrome. This is a true story, I would tell you. Dr. Jerome Lejeune, the world dean of geneticists, told this in Brighton, England, at the 16th annual conference on the family. He said, I was speaking to a group in Paris, and at the end of my talk, an older white-haired man came up, and he said, I must tell you a true story. My father was telling this story to me. He was a doctor in Austria years ago, delivered many babies. And on one night in the same small Austrian village, he delivered two babies. One had a very weak cry. She was Down's. The other, a male baby, had a very strong cry. He said, my father told me he did not even remember anymore the name of the female baby, but when her mother had a stroke in old age, she fed her mother the soup and took care of her. But he said, I will never forget the name of the male baby. His name was Adolf Hitler. True story. Not made up for this presentation. Two babies the same night in Austria. One a weak cry, one a strong cry. We would give back to God the defects. In closing, ladies and gentlemen, I'd respectfully submit that this case is, again, in fact, the judgment of Solomon. It is a very old judgment. It is a 3,000-year-old judgment. But it is a judgment that we're presented with in this type of a case. We have two mothers, one wishing that the baby might live, the other saying that the baby must die. And I'd respectfully proffer, ladies and gentlemen, that the true mother is the one who says the baby must remain whole. And I'd respectfully ask that your hearts and minds in your final deliberations this evening be on the side of Solomon. Thank you.
Thank you, Mr. Palmer. Mr. Nikas, you may address the jury.
You know, the great thing about poetic and moving language is it moves the heart. But what we're about tonight is the mind and reason and the law. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. So said the United States Supreme Court in Planned Parenthood versus Casey in 1992. This case also lies at the heart of liberty. Ladies and gentlemen of the jury, I want to thank you for your willingness to serve, your patience, and to remind you of the oath you took to enforce the law, not as you might wish it to be, not as it once was, but as it actually is now. Now, just what is that law? The law relevant to that case, and I submit to you the law that is dispositive of this case, is the U.S. Constitution as definitively construed by the U.S. Supreme Court in Roe v. Wade and affirmed again in Planned Parenthood versus Casey. Roe and Casey are unambiguous and unlimited. Unambiguous because their legal command or message to us is clear. A woman has a right to choose to terminate her pregnancy. And the message is unlimited because there are no real limitations or qualifications on the right recognized in Roe and Casey. Issues discussed today about who is the mother, or who might care for the child, are frankly, absolutely, legally irrelevant. But you might say, what about the limitations of the abortion license set forth in Casey, where Casey suggests that after viability, restrictions may be imposed on the abortion license? It's a fair question, but it's no problem. First, in this case, the fetus that Mrs. Jones is carrying is not yet viable. And even if it were viable, it's no obstacle. Because, as Casey points out, even after viability, if a woman's health or life are at risk, she may choose to terminate that pregnancy. And you must read Casey with the companion case that came down the same day as Roe, and that is the case of Doe v. Bolton, in which the court held that health is broad enough to sweep within its ambit mental health, mental suffering. The reality is, if a woman is suffering mentally during a pregnancy, she may, from the moment of fertilization to the moment of complete expulsion of the fetus from the woman's body, exercise her fundamental right to choose to terminate a pregnancy. It is absolutely clear. Under Roe, under Casey, under Doe, Mrs. Jones has a fundamental right to choose to terminate her pregnancy, and she chooses to terminate this pregnancy. But even if Roe, as Dr. Hook testified, does not apply, you must still rule for Mrs. Jones. The contract at issue would control. Now, it's very interesting. Let's think about what Dr. Hook just testified to. He says, first, generally, I don't believe in surrogacy contracts. Now, that's also corroborated by Dr. Mitchell, our witness, who said, not just in general, but in every case, those kinds of contracts are invalid and therefore unenforceable. But Dr. Hook makes an exception, conveniently, for the so-called rescue surrogacy contract. But let's think about that concept. It is Mrs. Smith who created the crisis which demands the rescue. And when I asked Dr. Hook If a mother places her child on the ledge, would that be considered a moral act? He unequivocally said no. So I submit to you that the contract is invalid, and then you fall back on Roe. But even if it is valid, we still win. Simple. There's a provision in the contract that says that Mrs. Jones, and only Mrs. Jones, makes the decisions regarding her health and the pregnancy. And the only evidence you've heard tonight is that she is suffering great mental anguish. Under Roe, we win. If the contract doesn't exist, we go back to Roe, we win. The contract is valid, we win. It is very simple. And all the flowery language in the world can't change the law and the facts as you've heard them. And I want to leave you with just one thought. We've heard a lot tonight from plaintiff and plaintiff's counsel about the temple of the womb. Well, let me submit to you that there is a greater temple at issue here. It is the temple of the whole person, the temple of the mind and the heart and the body. And that temple is greater than the part. And as Casey pointed out, only when a woman is free to make these most intimate and self-defining decisions can she be truly free, truly human. So as you consider the facts and the law, I know you will rule with Judge Young that the injunction be denied and that my client be allowed to make the decision most appropriate for her. And only my client makes that decision. Thank you very much.
Now, ladies and gentlemen, ordinarily at this point in a jury trial, the judge would read to the jury the law that the jury would apply to the facts as they find them to be. I'm going to give you just, and that's called a charge to the jury. I'm going to give you just a little different charge tonight. So pay careful attention, and I'll be as brief as I possibly can. Ladies and gentlemen of the jury, the case you've just heard presents for your consideration several moral issues, several medical issues, and several legal issues. The issues that I recited to you for your consideration at the commencement of this lawsuit, as you can now see, amounted only to the tip of the iceberg if we just changed the facts ever so slightly, one way or the other. I don't know how many combinations of the facts we could put together to have different verdicts, but they are myriad. Therefore, your charge, your instruction, is to give very careful consideration in the days and the months ahead to the dilemmas, to the issues, and to answer in your own minds and your own hearts the questions posed during the course of this trial. The facts upon which our case is based comes from real patient and real client situations. The case was only slightly altered to highlight the ethical, medical, and legal complications which so often arise in surrogacy situations. No two cases are the same. The case you may be presented with next week may be more difficult or less difficult, depending entirely on what the facts are in a particular case. It depends upon the parties, it depends upon their lawyers, it depends upon their physicians, it depends upon their clergy, their social, and their political backgrounds. All of those things go into the mix. Our goal tonight has been to create an atmosphere which would be conducive to causing you to think about the moral issues, to think about the legal issues, to think about the medical issues in a way and in a manner which you probably wouldn't otherwise have undertaken. If we've been successful, it's our hope that your creative juices are now freely flowing and that we will have stimulated you toward a continuing dialogue with each other in an effort to resolve together these issues presented and the many additional issues that will be presented in the future. Now, I'm going to ask if we could have the house lights up so I can see a show of hands. I'm going to ask you to help me decide the verdict in this case. I first of all would like for you, by show of hand, to tell me who the mother is in this case. Do you believe it's Ms. Smith or do you believe it's Ms. Jones? How many of you believe it's Ms. Smith? Thank you very much. Lower your hands. How many of you believe it's Ms. Jones? All right, the decision on that case is for that issue is for Ms. Smith. I've told you already that under the applicable law of East Dakota, there can only be one woman who has the decision-making capacity concerning the continuation of a pregnancy. And I ask you, who has that capacity in this case? Is it Ms. Smith or is it Ms. Jones? How many of you believe it's Ms. Smith? Thank you. How many of you believe it's Ms. Jones? All right. I'm going to call that in favor of Ms. Smith. It's close. The next question I need to ask is gestational surrogacy an ethical, valid form of assisted reproduction? Yes or no? How many of you think it is? How many of you think it is not? Thank you. Do you believe gestational surrogacy contracts should be legally enforceable? Yes, raise your hands if you believe they should be. No, raise your hands if you think they should not be. Close again, but I believe the yeses won. Ladies and gentlemen of the jury, can an individual waive her Roe versus Wade rights by way of a surrogacy contract? If you believe a person can waive those rights, signify now by raising your hand. Thank you. If you believe those rights cannot be waived, would you raise your hand? The yes answer is the obvious one from the show of hands there. Now finally, ladies and gentlemen, should this court grant the plaintiff, Ms. Smith's request for an injunction, thereby preventing Ms. Jones from having an abortion? If you believe the court should grant the injunction, would you kindly raise your hands? Thank you. If you believe the court should deny the injunction, would you raise your hands? All right. The injunction will be granted, and it is so ordered. And Mr. Palmer, you will prepare an appropriate order that will reflect the judgment of the court in this particular case.
Unsullied by us humans, sex is a very good part of human life.
We live our lives in a great deal of hypocrisy, telling our children to do one thing while we do something else.
The quest for control. We all would love it if our lives were a bit more controllable.
Discussions within the Christian community about these questions will be primary for the survival of the Christian community.
He said he didn't want to be a father against his will. Mary said he already is a father. I'm reading this paper. He said nonsense. They're only potential life. She said they are lives with potential. So the debate was joined. I said to my wife at the kid, listen to this. I look in the paper for the name of the lawyer. His name is Christian Barry. I'm not knowing him. Long distance information. I get him on the phone. He's hesitant to talk to me because the press from all over the world was calling him. I said, the one man in the world who can help you is a man by the name of Jerome Lejeune. He said, do you think he will come? Because if so, I think the judge would delay the case to enable him to get here. I said, I don't know. I'll have to call him in the morning. I did. I told him a little about this. He said, Martin, this is incredible. This is the judgment of Solomon. It is a 3,000-year-old judgment. I did not think it could reoccur in human history. It is reoccurring. But do you need me personally? Can't you use some of my writings? Martin, the Holy Father has asked me to speak to a group of teenagers in Spain this week, and then we have the largest consult in the world, 5,000 Down syndrome children. They come from all over Europe. This week they want to see me personally. Do you need me in person? I said, yes. There was a pause. He said, well, call me back in a half hour. I must call the airline, and I must telephone to my wife. She is in Denmark, and if she discovers I have gone to the U.S., she will be suspect. He flew to Dulles. I met him. We went to Tennessee on the little local plane, United. Watch this man who is French work with our language. And then in a moment, his working with our language will introduce this eminent jurist. He said to me in the plane seat, Martin, tell me, what is it that this judge in Tennessee must decide? I said, well, he has to decide if these human embryos are person or property, because if property, he would divide them like the silverware or the baseball playing cards in the divorce. If person, he would enter up a custody award. Watch the mind of this man work with another language. Well, I would propose to say to the judge, Mr. Presidente, I would say they are person and not property, because they are the only property which has the property of building themselves. And he so testified, and he said, I remember at the close of his testimony, Judge, that this was the judgment of Solomon, and he would hope that Your Honor would be on the side of Solomon. And Judge Young kept us all on pins and needles for months, and not a hint was to the press or anybody. And when you read his opinion, you'll see why, the time and the effort that went in this. I truly believe that this jurist's life had prepared him for this case. Now I want Dr. Lejeune to introduce him. Posthumously, we were in Brighton, England, and Dr. Lejeune was addressing the 16th Annual Conference on the Family. And he was telling about this case because there was such a great interest in the European press. Before he died, he'd done the translation to the Italian edition of this, and I don't know, the Danish, the Spanish, it's circled the world, the judgment. And he was talking to those in Brighton, and he said, again, watch him find insights in our language that we would entirely miss. He said, I was asked to testify for Mary of Maryville, Tennessee, who was represented by the lawyer Christian Barry and the judge who was to make the judgment for the very young. His name was Judge Young. And as I went home on the plane, I had to think to myself, my name in French, it means the same. The young, sometimes. Truth ventures coincidences that science fiction would not dare. Do you see the reason for my introduction? You are honored to have with you the providential choice for the judgment that has circled the world. And Judge Young called me the other day. He somehow found me at my hotel room, and he said, "Martin, is there anything I could be thinking of?" I said, "If we could ask you to step out of character at the end of the case, if you'd be so kind." Yes, there would be. I wrote him a letter, faxed it, because he caught me off guard with the question. And I then later said to him on the phone, as you fly into our city and you see the towers of Chicago popping up along Lake Michigan, and you think of the people in that city and the decisions that this new reproductive technology brings about, would you share with us the wisdom of your heart? You see, like the two lines in an electric cord to make the light come on, there were two things necessary to bring about the judgment of Maryville: the judgment of the scientist, the doctor, Lejeune, and the judgment of the jurist. Both were needed. Everything else, the lawyers, the courts, served the two. The first part of that equation is forever passed into history. We have the second half of that providential equation with us, and I would ask Judge Young if he'd be so kind to come up now. And I don't know if he's really thought what all he will say, but to just share with you from his heart at this moment.
Thank you. Mr. Casey, with your permission, I'm going to just stay right here. Is that all right?
With your permission, I'll put down the stand.
Okay. Oh, goodness. Thank you, sir. Ladies and gentlemen, from the bottom of my heart, I really earnestly appreciate the opportunity to be a part of your conference. It's been an uplifting experience for me, and to be here with my friend Martin Palmer again and to make so many new friends is an experience for me that I find hard to put in words, because I have an idea that we're going to be talking about together about some of these issues for many, many months and years probably to come. So I thank you so much for the opportunity to be with you. And I know the hour is late, and I have some prepared remarks, and I'm going to read them to you, because I found that when I speak extemporaneously, I tend to overkill things, and now is not the time to do that. In August, 9 years ago, it was my privilege to preside over the very first lawsuit in history concerning the disposition of human embryos. And because the case was one of first impression, there just was no law to guide me in the decision in the case. It drew media attention from literally around the world. Hundreds of news people descended on my little town of Maryville, Tennessee, the population of which was about 40,000 at that particular time. And for some days, some 4 days, in that hot August, people talked and talked and talked of the 7 cryogenically preserved embryos created by Mr. and Mrs. Davis, who resided in our community, who had filed a divorce action and were trying to be divorced amidst all of this attention, all this fuss from all over the world. No jury was involved in hearing the case. In Tennessee, typically and traditionally, equity cases, domestic relations cases, are heard by judges only. That is, it's not impossible to have juries, but typically judges hear those. The judges determine the facts, the judges determine the law that applies to the facts as he finds them to be. And that was my case. I did my job as a judge in the Davis case as I had done my job in so many divorce cases before the Davis case. That is, I very carefully decided what the facts were based on what the witnesses told me the facts were. And I applied the law, the legal principles that I knew that were applicable to those facts under Tennessee jurisprudence, and the facts that I knew to be just and equitable in that particular case. There was very, very little law for me to consider. I was simply flying by the seat of my pants. For in the Davis case, you might think, Judge, you could have looked to some contract law, but in the Davis case, there was no contract. Nobody had thought to make even an oral agreement about the disposition of unused embryos, much less put anything in writing. The physician who helped create the embryos didn't do it for his firm. Mr. and Ms. Davis didn't do it for themselves. Nobody thought that anything would ever come of this sort of a situation, and we found ourselves hopelessly deadlocked with what to do with 7 frozen embryos. The decision I had to make then 9 years ago was simply whether these 7 frozen embryos were people or property. Several expert witnesses gave testimony in the case, but one witness will forever be remembered by me as a witness who gave the absolute most compelling testimony I have ever heard. And to this day, no other witness has surpassed that testimony. That witness was Dr. Jerome Lejeune, the world-renowned geneticist who you've heard much about at this conference already. And to use his words, his own words, from a little village on the banks of the Seine River, from Paris, France, all the way from Paris, France, to Maryville, Tennessee. Dr. Lejeune spoke from his heart and with his scientific mind to make it clear that a man is a man from his very earliest form of life until that life is ended. He backed up that claim in a very simple way by explaining in a very elementary way the complicated concept of DNA so that I could understand it. It was easy to grasp. It was easy to understand. And it was easy for him to show me how it applied to the Davis case. Dr. Lejeune and I met by the providence of God. God spoke through Dr. Lejeune, and I was compelled to listen. The facts and the law dictated in the final analysis that the court's judgment must be that these frozen embryos were people and not property. It was the first case ever to hold that life begins at conception and not at some arbitrary time to be decided at the whim of a legal analyst, a medical specialist, the clergy, or some bureaucrat from the state. On appeal, the Tennessee Supreme Court completely ignored the facts of the case. They set out to and they accomplished a political agenda, and they reversed the case. So now in Tennessee, human embryos are marital property, just like the toaster, just like the TV, just like the family automobile. In the almost 9 years since Davis, several additional suits have been brought, and all of these suits are very similar to the Davis suit, but very, very different in many ways. To my knowledge, there have not been 2 lawsuits near enough on the facts to confidently say that a trend has been established in the law. The law governing in vitro fertilization and the subject of surrogacy continues to develop, just as the science which facilitates those possibilities continues to develop. We live in a complex age of science and complex law. The moral dilemmas don't get any easier to deal with. Because of the complexities of the moral, legal, and scientific issues we have created, it's high time, yes, it's past time, for us to design and actively seek the adoption of solutions to some of these problems we see on the horizon. And I have two recommendations for your consideration. One of them surrounds Dr. Lejeune's proposal of law. Before his recent death, Dr. Lejeune wrote and had a sponsor seek the adoption of a proposed law in the state of France, in the Senate of France, beg your pardon, dealing with the health of the human person. The thrust of the two provisions of that law that are pertinent to our discussions here tonight made it clear, first of all, that no human embryo should ever be submitted to any exploitation. And second of all, that manipulation of the human genome never be permitted except for therapeutic interventions, such as in the case of organ donations under strict circumstances. I think we should strive for the approval and the adoption of these concepts on a national level. The second recommendation I make to you is much easier to accomplish. If any person in this room believes that the problems presented here tonight through this moot court presentation could be resolved by the legal community alone, I tell you they will not be. If anyone here tonight believes that these problems can be solved by the scientific community or by the clergy, I tell you they cannot alone. At the very least, then, we must begin and maintain a constant dialogue among all of us to hopefully resolve some of these issues that arise from the reproductive revolution before they become problems for us. And perhaps more important than anything else, we need to start talking to one another in simple language. We need to scuttle the legal ease where we can do so. We need to talk in simple, non-scientific terms with one another about real moms, about real dads, and about real unborn children. And when we adopt that very childlike approach to some of these problems, I think that we will hear and understand each other much better. Just one last word. Just as our individual DNA has already written upon it the story of who we are, I am personally persuaded that the Creator has already written upon the hearts and the minds of each of us the story which reveals the reason for our existence. Some folk call it God's will. I'm persuaded that our Creator has also written upon the hearts and the minds of each of us in this room the answers to many complex questions about the issues of the reproduction revolution. I suggest to us that we just be still and listen, and the answers will come. Thank you so much.